I'm going to talk today a little bit about creditor collection efforts, both before and during and after Chapter 7 bankruptcy. Generally, once you elect or decide that you need to file a bankruptcy, if you come into this office, we'll provide to you a card so you know what to tell your creditors when they call you. Your creditors will attempt to write you, and we tell all our clients, unless it's a student loan, back child support, or recent income taxes, you can ignore those letters. But if a regular creditor, such as a credit card creditor or a student loan creditor, or a medical provider creditor contacts you by mail, you can just file that away and make sure the debt is included on your bankruptcy. If they call you and you tell them that you are represented by a law firm and you are talking to a collection agency or a third-party debt collector, once you advise them of the representation, they must immediately hang up. It is illegal for them to talk to you, and if they continue to talk or harass you or start calling family members or make repetitive calls, you might have a claim against them under the Fair Debt Collection Practices Act. We can refer you to an attorney that handles those type of actions. Generally, there's no fees, and the creditor, if found guilty of violating that section of the federal law, will owe you statutory damages of approximately $1,000. Once you file bankruptcy, it's illegal for any creditor to communicate with you unless they're collected for current back child support. The creditor, while you're in a Chapter 7, that is between the time you sign your papers and get a discharge, must ask the bankruptcy judge for permission to try to collect on their debt. Since it's going to be discharged, generally they will not. However, some creditors will try to maybe step over the line a little bit. The line in the sand is generally called the automatic stay. If a creditor willingly contacts you, you have a claim against them for violation of the automatic stay. That can result in actual damages, for example, your time to come to this office, attorney fees, any costs involved, such as gas to your car, lost wages, and punitive damages if what they did is willful. After the bankruptcy is discharged, if they communicate with you on a discharged debt, you have a right to sue them after you tell them about your bankruptcy for a violation of the bankruptcy discharge injunction. Generally, once you tell a creditor that you have filed, you give them our name, they will quit communicating with you. But if a creditor does start harassing or does become abusive, make sure you let us know if we are representing you. Thank you.